were the actions of the chief judge of the provincial court in pressuring another judge to disclose her private medical information. And these actions include meetings, they include emails, they go so far as to include the chief judge having a letter on the chief judge's letterhead sent to this judge's doctor without prior consent, requesting private medical information.
Welcome to episode 12 of the second season of Justice Center Weekly, podcast from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and with us is lawyer Marty Moore. Marty is bringing us an update on the Brinton matter. This is the case where Nova Scotia Judge Rickcola Brinton is challenging the dismissal of her complaint against the former chief judge of the provincial court for the chief judge's treatment of her during the court system's COVID vaccine mandate. And with that, I'll turn it over to Marty to give us the particulars. Marty?
Yeah, thanks, Kevin. I just got back from Halifax, where we had the full hearing of this matter, which happy to unpack for you there. It was heard in the Halifax branch of the Nova Scotia Supreme Court before Justice Brothers, who is now going to decide this matter. So happy to dive in and unpack this matter, which all relates around the conduct of a chief judge at the Provincial Court of Nova Scotia and how she treated another judge who refused to disclose her private medical information. Everyone acknowledges it was private medical information, and that's what the complaint was about. So this stems back from 2021, where on November 1st, the chief judge imposed, without a lot of reference to any kind of authority that the chief judge had to do this, imposed a requirement that every single judge in the Nova Scotia Provincial Court that would appear in court and hear cases, which is what judges do, had to be vaccinated with the COVID-19 shots. And so this happened in November 1st, and so that and subsequent events are what are at issue in this complaint that was filed by Judge Brinton against the then Chief Judge Williams.
Okay, well, are you challenging her authority, that is the chief judge's authority to do this? I heard some hint of that in what you were saying, or maybe I misinterpreted. Could she actually impose this vaccine mandate?
Right. Well, that's a good question. And actually, that issue is being challenged in a second case, which is a much larger case. It's a statement of claim that's been filed against the provincial court and Judge Williams regarding whether or not essentially the suspension of this judge for not disclosing her private medical information was reasonable. Was it lawful? Those issues are at stake in a second case, also being led by our lawyers on behalf of Judge Brinton. So that other issue is dealing with, was it lawful? Was it legal? Did it violate charter rights to impose this? What's at stake in this particular case, which was heard on Thursday, is were the actions of the chief judge of the provincial court in pressuring another judge to disclose her private medical information. And these actions include meetings, they include emails, they go so far as to include the chief judge having a letter on the chief judge's letterhead sent to this judge's doctor without prior consent, requesting private medical information about this judge. And then a follow-up phone call. So pressure not only onto the judge, but also pressure onto her doctor to disclose private medical information. And so the assertion of the complaint, which I agree with, is that this amounts to judicial misconduct. And when a judge engages in behavior which undermines public trust in the judicial system, which is unethical, the place where that behavior is addressed is through a complaint. Federal judges are dealt with through a complaint to the Canadian Judicial Council. Here in Nova Scotia, there's a separate judicial council that's set up via statute to adjudicate these complaints. And so that's what happened in this case, is Judge Brinton, in response to this conduct, pressuring her to disclose her vaccine status, her private medical information, filed a complaint saying, I believe this conduct is wrongful. I believe it violates my ability as a judge to carry out my duties. And that kind of interference, that kind of pressure, preventing her from sitting on the bench even, and threatening that you will never sit on the bench, and even threatening a judicial conduct complaint against Judge Brinton for not disclosing her medical status. All of that pressure, Judge Brinton asserted in her complaint, amounts to a violation of the chief judge's ethical obligation and amounts to misconduct. And really, what's at stake here is something called judicial independence at the end of the day. And that's the concept that no one should be interfering with the judge's ability to hear and decide cases. And it's almost ultimate interference when a chief judge says, well, because you object to disclosing private medical information, you will never hear another case again. And that resulted in a line of pressure. And so a complaint was made. And so the process of making that complaint is that a judge would, or any member of the public, if they have a complaint, a concern with the conduct of a judge that they believe amounts to judicial misconduct, which is actually quite a high bar, they make a complaint to the judicial council that has authority over that particular court. In this case, the first person that that normally hears a complaint against a judge in the provincial court is the chief judge of that provincial court. And so in this case, the complaint was against that judge herself. And so the complaint was actually provided to the Chief Justice of Nova Scotia, Michael Woods. And Mr. Woods, Justice Woods, heard that complaint only in written submissions. And so there's a detailed statutory process. It's actually a rather elaborate process, as you might guess. Judges hearing complaints against other judges, there's lots of different layers to get through. And the first layer is a screening process. It's is there validity to this complaint at all? Is it frivolous or vexatious, which are legal words which mean, essentially there's no basis for this complaint whatsoever. It doesn't show even good faith in making it. It's a frivolous, it's even, arguably a bad faith complaint. Another aspect at this stage is for a screening judge to look, well, is this complaint supported by any evidence at all? And then a third aspect at that stage is to say, well, does the judicial council have jurisdiction to decide this complaint? Now, jurisdiction of a judicial council to decide a complaint is limited to misconduct. It's not limited. It doesn't go to the extent that says, well, this judge decided against me, so I'd like to file a complaint. Well, no, you file an appeal. But this is specifically related to conduct that amounts to, a breach of the judge's ethics. And so at this initial stage, a judge is there to fulfill what's generally called a screening function. You just look at the complaint, kind of does it pass the smell test, or is there any validity to this complaint? Now, the complaint that was filed on behalf of Judge Brinton is quite lengthy. It outlines a series of actions by the Chief Judge Williams over months of time, and again culminating essentially in a threat saying you will never sit in a courtroom again unless you disclose your medical information, and if you fail to do that, you will also have a complaint sent to judicial council against you. And then further conduct that amounted to, as I mentioned, the chief judge going directly to a doctor, Judge Brinton's doctor, to get that private medical information directly. And so, obviously, in my view, that's quite ghastly behavior for a member of the legal profession, never mind a judge, to be engaging in. So the first three hurdles of, is there any evidence to support it? Is it within the judicial council's jurisdiction, or is this frivolous or vexatious, did not appear to be of a concern in this particular case. Now, what happened is the Chief Justice Woods, in reviewing this complaint, ended up, looking at this complaint and and decided to reach out to Chief Judge Williams, the one who had engaged in this conduct against Judge Brinton, and in doing so said, would you have any response to this complaint, and invited submissions in writing, which was somewhat unusual. We're at the screening stage. We're not at the arguing stage. Of course, lawyers are very happy to write long written arguments, and judges were lawyers first, so you can imagine that when you're asked for a response in writing, a lawyer's pretty, they can take their time and do the best job they can. Not normally something you would see at a screening stage. In fact, I've never seen it at a screening stage in any of the case law that we've reviewed. But that's what happened. At this initial stage, the Chief Justice wrote to Chief Judge Williams, and in fact, Chief Judge Williams' lawyers then responded, saying we need an extension of time because we need more time to prepare our written response. And so they sent in a lengthy written response to the complaint, which, is entirely fine for them to do that. If I was facing a complaint against me that alleged I had engaged in unethical behavior, I would probably have a lengthy response to that as well, asserting legal principles and factual inconsistencies, etc., which is what the response on behalf of Chief Judge Williams attempted to do. Now, what happened after that is where the problems really start. And maybe the problem started with the Chief Justice asking for detailed written submissions at the screening stage. And when the Chief Justice received those detailed written submissions, the Chief Justice did not provide them to Judge Brinton and her lawyer, just kind of kept them to himself. But then the Chief Justice asked both counsel for Judge Williams and counsel for Judge Brinton to respond with whether or not they felt that the Judicial Council, namely the Chief Justice at that point, had the jurisdiction to hear this complaint. And so those two submissions were provided. And again, there wasn't an exchange of Chief Judge Williams' submissions provided to Judge Brinton. And so it's difficult in a legal case to argue, but it's very hard to argue against another side and the positions made by another side when you're not allowed to see those positions. And so that was the position that Judge Brinton was in responding to the issues raised by the Chief Justice. Because the Chief Justice was saying, I'll get submissions from Judge Williams' counsel, and I'll get submissions from Judge Brinton's counsel, but I won't let Judge Brinton's counsel see the submissions provided by Judge Williams. And so there's an aspect, in olden times, we would call it principles of fundamental justice, in my view, were violated there. More recently, they call it procedural fairness. Something's not quite fair in how this process was being worked out. And so after those submissions were exchanged, Chief Justice Woods issued a written decision. And in his written decision, he said, I am here to exercise a screening function, kind of like I outlined. But then Chief Justice Woods went on to say, and I'm going to apply a test that actually applies at a committee stage, because there's a couple stages to this process, as I alluded to before. There's the screening stage. There's actually a second stage where a case is referred by a reviewing judge to the Chief Justice, and the Chief Justice has the opportunity to make a decision. And then there's a third stage where a committee is struck, a committee that would involve a member of the bar, a member of the judiciary, and also a member of the public to review the complaint and see if it's meritorious. And so, of course, at this stage, the Chief Justice is exercising the authority of actually the Chief Judge of the Provincial Court, although he's reviewing a complaint against the Chief Judge of the Provincial Court. So the Chief Justice is saying, I am exercising my authority to screen this application. But yet, instead of applying a test that would normally apply at the screening stage, which is this frivolous or vexatious? Is this without any evidence backing it up? And is this without jurisdiction for the Judicial Council to hear? The Chief Justice applied the test that applies to the screening committee, which is quite a different test. It's a much more involved test. It's a test that applies after an investigation of the various claims and assertions has been made. And so the Chief Justice goes through that test in his written decision and says, well, after reviewing this, I don't find that the complaint has merit. I don't find that this complaint is going to be successful in finding that Chief Judge Williams engaged in judicial misconduct in how she pressured Judge Brinton to disclose her private medical information. And so receiving this complaint, this decision dismissing the complaint, it was a little bewildering, because here you have a judge saying, I am exercising the screening function. I am proceeding under this screening application stage of the statutory authority that I have, but then applying a test that applies at a much later stage in the proceedings. And never once analyzing whether the case was supported by evidence, whether the case was frivolous or vexatious, or whether the case was within the jurisdiction of the Judicial Council, yet citing that very provision in dismissing the complaint. And so this would be a situation which I would say is a classic situation of an unreasonable decision. An unreasonable decision to dismiss a complaint against a fellow judge. Now, one might, venture to speculate as to why the Chief Justice of Nova Scotia would dismiss a complaint against the Chief Judge of Nova Scotia, who was implementing and then trying to enforce, essentially, a vaccine mandate. Of course, all levels of court in Nova Scotia implemented similar vaccine mandates. And so chief judges were very much involved in that process. But we don't need to speculate as to why this decision appears so unreasonable. All we needed to do as counsel for Judge Brinton in this matter was to come to the Nova Scotia Supreme Court and on a process called judicial review and say this decision on its face is unreasonable. It does not bear the hallmarks of transparency, intelligibility, or justification. And in fact, it should have referenced the very important issues that were at stake here, namely issues of judicial independence. Can a chief judge really say to another judge who's been appointed to hear cases, you are not allowed to hear any cases until you give me your private medical information? Is that really the standard to which we allow chief judges to interfere in the hearing of cases on the bench? Was there fairness in how the Chief Justice reviewed this complaint against the Chief Judge? And so these were issues that were raised before the court. Written arguments, fulsome written arguments were received, not only on behalf of Judge Brinton, but also on behalf of the Judicial Council, and also on behalf of former Chief Judge Williams, against whom the complaint was made. And so in court on Thursday, we had a set of lawyers for the Judicial Council who had flown in from Toronto. We had a set of lawyers for Judge Williams, who had also flown in from Toronto. And then we had a set of lawyers for the Attorney General who didn't participate too much in arguing. That would be the Attorney General of Nova Scotia. So it was a rather full courtroom. And of course, there was lead counsel James Manson on behalf of Judge Brinton and myself there in the courtroom as well. So it took the full day to argue this case out there last Thursday.
Okay, just to clarify then, you're saying that because he took on this duty of a committee, that is the chief argument that you're saying that this is unfair because I can't say usurped, because it sounded like he had the authority, but he really shouldn't have adopted the test of a committee? Right.
Go ahead. The case law does not use the word usurp, yes, Kevin, okay. But I think the idea is there. The case law uses the word arrogate to themselves the power reserved for another body. And so here, yes, a very important aspect of the case is saying, look, the statute says that when you're reviewing a complaint, you're allowed to screen it. And there's a particular test there. Is it frivolous or vexatious? Is there any evidence? Is it within the jurisdiction of the Judicial Council to hear? A very simple test to apply. That's the test he said he was relying on. He cites that provision. However, he says, and I'm going to apply the test that is for the determination of a complaint at a committee stage after a full investigation has been complete. And so yeah, on its very face, you're saying, well, you've jumped ahead to stage number 3, but the test you say you're applying is at stage number 1. So all of this analysis on, evidence and argument and whether or not judicial and, whether or not a chief judge can do this or not, well, that would all apply after there's an investigation, normally after there's, written submissions that both sides are actually engaging with on the issues. In this case, he got written submissions from former Chief Judge Williams, but never provided Judge Brinton with a chance to respond to those submissions. So he was not receiving the full argument on the issue. But of course, at a screening application, you wouldn't always expect that. So there is the issue of, look, you're just not following the statute. Something called ultra vires. You're outside of the lines that the statute has allowed you to be in. That's one of the arguments. Another argument is this decision is not procedurally fair. If you're going to dismiss a complaint in this manner and you're going to be receiving detailed written submissions from counsel, well, then you need to be providing those submissions to the other side in order for you as the decision maker to hear both sides, but also for the complainant to be able to respond to what points the other side is making. Because if you don't allow for that, then you're not really having much of an argument. It's just two ships passing in the dark. And then, of course, the third aspect under which this case was brought is an aspect that says, look, you're dealing with a chief judge requiring compelling speech from another chief judge about their medical information. That's compelled speech that engages an issue called freedom of expression in Canada. Judges should be aware of this issue. And so a decision that says, well, it's totally fine what the chief judge did here, but fails to grapple with the chief judge really forcing another judge to disclose private information that they don't want to disclose, or that other judge will not even sit on the bench and hear cases anymore. That's a concern under freedom of expression. The Chief Justice should have noted that concern and should have at least attempted to balance the interests between freedom of expression and this alleged need for the Chief Judge to have someone else's private medical information. And of course, this right of the public and really Canadians at large to have an independent judiciary, a judiciary where a judge is able to hear cases and go to court. So you have, the executive appoints judges, and then those judges that are appointed hear cases and decide them. But when you have the executive appoint judges and then a chief judge saying, well, this judge won't tell me information, so I'm not going to allow her to sit on the bench. Well, now you have a problem with judicial independence and a real perception, if not reality, that there's a lack of independence and someone's being interfered with. And this had real consequences, Kevin. Chief Judge Williams, when she imposed this requirement on Judge Brinton, she thwarted Judge Brinton's ability to hear and decide the cases that were before her. These include cases, horrific criminal cases, cases of abuse of children, and all of the worst things that you can think of. These are the cases that judges hear. And when you prevent a judge from hearing those cases in a timely fashion, justice is not served. And so you can look up stories where accused child molesters are being let off because of this action. It's not an action without consequences, what happened here. So the way it occurred and the threats that it occurred are, in our view, amount to just a system of pressure on Judge Brinton. And when Judge Brinton stood on her principles, and her principles were quite clear, she outlined them long before a vaccine mandate was imposed. She said, I object to this idea that the courts need to publicly state that we are all vaccinated. Not every member of the public is going to be vaccinated, and particularly minority communities that aren't trusting of the government's every word for various reasons. They will feel that if we align with this government narrative on vaccination, we are picking a side. We lose that view of neutrality. And so she made her position clear on this, and she stood by that position. But the chief judge was noting that certain members of the bar were asking about whether all judges were vaccinated, as if lawyers have a right to demand the private medical information of a judge, which is quite shocking. But this was the kind of pressure that was acceded to in this case. And then great pressure was put on Judge Brinton to disclose her private medical information against her prior stated principles and against what she believed was right. And when she refused to do that, she was told that, look, you will be sent to the Judicial Council for review of your ethical conduct, and you will not be allowed to hear cases. And so these arguments were made. James Manson made arguments here in Nova Scotia on behalf of Judge Brinton. Justice Brothers heard those arguments. She was very engaged in the case that was before her. I believe she understood the issues well. Then you had two sets of lawyers from Toronto argue again for the Judicial Council and also for Chief Judge Williams. And then James Manson got up in reply. Now, to get into the details too much, essentially, a lot of arguments were made that said, look, the fairness issue isn't a big deal. Complainants, even if she's the judge, she's making a complaint against another judge. She doesn't have any right to get any of this information about what Chief Judge Williams was saying to Chief Justice Wood, who was reviewing the complaint. And they also said, and this idea that, the judge, Chief Judge Williams behaved unethically when she wrote to the doctor. Well, the doctor had actually declined to provide those medical information, so no harm, no foul. It's just someone asking for your medical records, but she didn't get it. And then they came across another argument that said, well, and, Judge Brinton was not actually referred to the Judicial Council because she's actually been on disability leave, stress-related disability leave, really, since this situation occurred. So really, we haven't been able to prove that Chief Judge Woods suspended Judge Brinton because, in fact, there was a medical leave at issue. Which is, again, there's another case that's going to deal with whether or not Chief Judge Brinton was constructively dismissed. She was told in no uncertain terms that if you return to work from your leave, you will be suspended and referred to the Judicial Council. So that issue is, the rightfulness or wrongfulness of that suspension is going to be at stake in a different case. But these were the arguments that were being made by the different legal teams there against Judge Brinton in the court. The Chief Justice's reasons were rather confusing, as I outlined earlier. And so counsel, especially for Chief Judge Williams, was leading the court to say, well, let's be sensible about this. Let's be sensible about what the Chief Justice really was doing, and then trying to say, well, even though the Chief Justice was citing a section that only applied to whether it was frivolous or vexatious or without evidence or without jurisdiction, and even though the Chief Justice was applying a test that went for a later stage of the process with the review committee, that's what the test they're supposed to apply. Well, really, the Chief Justice in this second stage, he could have just dismissed the complaint himself. So maybe that's what we should all just recognize could have happened, and he doesn't need to explain that to us. And so in reply, of course, we referenced the law from the Supreme Court of Canada, which said we're not allowed to go into a decision-maker's head on judicial review. They have to show by their reasons that their decision is reasonable, that it's intelligible, that it's showing these hallmarks of justification and transparency. And of course, in our view, the decision woefully fails to do so. And so we were able to respond to that, and Justice Brothers thanked all the lawyers in the courtroom for submissions, both in writing and orally. James Manson did an excellent job on behalf of Judge Brinton, if I may say so, and Justice Brothers is now deciding the case, and we'll be looking forward to a decision. As usual, Kevin, we don't have any date certain on which the decision will be released. It's certainly not a small situation. This is a case that I believe affects significantly many people in Canada. Of course, judges across the country were subjected to vaccine mandates, How those vaccine mandates were enforced and imposed is largely a matter of secrecy because, of course, judges don't normally speak out about the inner workings of the court. But in this case, a judge felt that it was necessary to do so to protect judicial independence, not only for herself, but for the public and for other judges. And so there's a lot of implications about the relationship between a chief judge and what authority do chief judges have to essentially remove other judges from hearing cases. And on what reasons can a judge do that? A chief judge, can they do that? And, to what extent can they go in pressuring another judge to disclose information to them, private medical information, which everyone acknowledges was at stake in this case. And so very interesting implications to this case. We'll certainly keep you updated when we hear a decision out of the Nova Scotia Supreme Court. Otherwise, we'll continue our work on this matter in the other case, which is, again, dealing with the lawfulness of the vaccine mandate itself and the lawfulness and legality and even constitutionality of suspending a judge and preventing a judge from hearing cases because that judge refuses to disclose private medical information. So that's a separate case, and there's a hearing on that actually in early July.
Okay, I just want to be able to differentiate between the two because, of course, I have to sort this out for the website as well. So maybe just finish off by telling me how I can differentiate between the two. Are they in front of different courts?
They are not in front of different courts, Kevin. So one case is in front of the Nova Scotia Supreme Court on an application for judicial review. That's the case that we've just discussed, whether Chief Judge Williams engaged in misconduct by pressuring another judge to disclose her vaccine mandate. To disclose her private medical information, or probably her COVID vaccine status. The other case is a statement of claim filed against, again, the court and Chief Judge Williams, arguing that the imposition of this vaccine mandate and the constructive dismissal and prevention of Judge Brinton from hearing cases at the Nova Scotia Provincial Court was wrongful, and that it violated the Constitution, it violated employment law principles. So that is the second case that is going forward on a motion, not a full hearing, but just a preliminary motion there on July 2nd. Okay.
Thanks so much, Marty. I think I've got it straight now. Okay, well, thanks for taking the time to update us on this case. Welcome back from your trip to Nova Scotia, and I look forward to talking to you again real soon.
Thanks so much, Kevin.